So, let's talk about an idea that's right at the heart of comparative law. It's called the functional method. And what's so fascinating about it is that it's both absolutely essential to the field and at the same time, maybe one of its most controversial ideas.
I mean, just look at this quote. To put it simply, this method is somehow both the most celebrated and the most despised idea among legal scholars. For its fans, it's pretty much the only way to do comparative law right. But for its critics, oh boy, they see it as everything that's wrong with the mainstream approach.
It really makes you wonder, doesn't it? What in the world is this thing that can provoke such intense loyalty and such deep-seated hatred all at the same time? Well, that's the puzzle we're going to try and solve today.
Okay, so here's how we're going to break it down. First, we'll get into why this whole thing is so confusing to begin with. Then we'll uncover the seven different ideas all hiding under that one label. After that, we'll get to its real purpose, bust 3 huge myths about it, and then finally, we'll see why this method really matters in our world today.
All right, so the first thing you have to understand is that the functional method is just notoriously difficult to define. The source material calls it a chimera, that mythical beast made up of parts from a lion, a goat, and a snake. And that is a perfect metaphor because the method is really just a mashup of different and sometimes clashing ideas.
In fact, the name itself is what's called a triple misnomer, which is just a mess. For starters, there isn't one method. There are actually a bunch of them. Second, what people call functional isn't always functional in the way a scientist would use the term. And to top it all off, some of the people who claim to use it aren't really following any clear method at all. So, yeah, no wonder everyone's confused.
So where is all this confusion coming from? Well, it turns out that functionalism isn't a single, neat theory. It's more like a catch-all label that's been slapped on a whole jumble of very different ideas over the years. And what's really wild is just how many different ideas get thrown into this mix. The functional method in law borrows bits and pieces from at least 7 different schools of thought. We're talking everything from ancient philosophy to modern sociology. And here's the kicker. A lot of these ideas flat out contradict each other. It's a real intellectual stew, and that's a big deal, because it means 2 lawyers can say they're using the functional method while talking about completely different things.
So if trying to nail down one single definition is a dead end, what do? We've got to shift our focus. Instead of getting bogged down in what the method is, let's ask a much better question. What does it actually do? What's its purpose when lawyers use it to compare legal systems?
And this is where we get to the absolute heart of the matter, a concept called functional equivalence. The big idea here is pretty simple, actually, is that different countries with totally different legal systems and traditions can still find ways to solve the same basic societal problem. Their legal tools might look nothing alike on the surface, but they achieve the same result.
Here is a perfect real-world example. So, society has a problem, right? People get hurt in car accidents and they need to be compensated. In England, the solution is tort law. You sue the person who caused the accident. But in New Zealand, they went a completely different way. They created a national no-fault insurance system run by the state. The legal mechanics are worlds apart, but they are both responses to the exact same problem. They are, you guessed it, functionally equivalent.
Okay, so now that we have that core idea of functional equivalence locked in, we can start to knock down some of the biggest myths that have grown up around this method. Let's dig into 3 surprising truths about what it's really for. The biggest myth by far is that functionalism is just a way to prove that deep down, all legal systems are secretly the same. But the reality is the exact opposite. By starting with a shared problem, like car accidents, the method actually becomes this incredibly powerful lens for seeing just how differently legal systems choose to tackle it. It's not about erasing differences, it's about highlighting them and understanding why they exist.
All right, myth number 2. This is the idea that you can use the functional method to go law shopping, to compare different systems and just pick the best one. But in reality, it's a terrible tool for that. Why? Because legal rules are almost never designed to do just one thing. A rule that's great at achieving one goal might be awful at another. The method actually forces you to see these complex trade-offs.
Let's jump back to our car accident example. New Zealand's insurance system? It is fantastic at compensation. Pretty much everyone who gets hurt gets paid. But it's not so great at deterrence, because it's a no-fault system. Now, flip over to England's tort system. It's way better at deterrence. It makes people think twice before driving recklessly. But it's super expensive and not nearly as good at compensating every single victim. So, which one is better? Well, it completely depends on what you care about most. There's no easy answer. And the final myth we're busting is that the whole point of this is to push the world toward one single unified set of laws.
But the core idea of functional equivalence actually gives you powerful arguments against doing that. I mean, think about it. If England and New Zealand are both effectively solving the problem just in their own ways, why on earth would we try to force them into a single system? It's not just unnecessary, it could actually make things worse. And all of this leads us to the method's true value, especially today. If it's not about proving we're all the same, or picking the best law, or creating one world government, then what is it good for? The answer is both simple and incredibly important. It's for understanding.
At the end of the day, the real power of the functional method is that it fosters a kind of intellectual respect and tolerance. It lets you look at a foreign legal system that, on the surface, seems totally bizarre, and it helps you understand the internal logic. It shows you that there are many, many valid paths to solving the same fundamental human problems. And this is not just some dusty academic theory. You see this principle in action all over the world. The European Union, for example, often issues directives that set a goal, but then lets each member country figure out the best way to get there using their own laws. Courts are more and more willing to recognize foreign judgments when they see they serve an equivalent function. It's all about promoting cooperation without demanding that everyone become the same.
So I want to leave you with this final thought. We tend to assume that understanding one another means finding all the ways we're the same. But what if the functional method teaches us the exact opposite? What if true, deep understanding comes not from trying to erase our differences, but from appreciating all the brilliant and creative and effective ways we have learned to be functionally different?